Good morning. I'd like to call to order the Board of County Commissioners. Today is Wednesday, March 14, 2018, and today we have a pair of work sessions scheduled with the County Council. And I know there's been a little bit of confusion out there. There is not public comment today. This is a work session, and it's a work session for the board, and we have two items in front of us this morning. We're going to start off with the Citizens Initiative process, and then we'll follow up with the board referral process, and this is so we can get some understanding of the history and the legal underpinnings of these two processes, and specifically, I think when we get to the referral process, there's been some requests from citizens about referring a pair of ordinances, and we'll probably get to discuss that then. But we'll start out with the Citizen Initiative process, which was a request from Commissioner Farr to have this portion of the work session so we can understand what role the board has and what role our staff has and how the Citizen Initiative process works for both charter amendments and ordinances here in Lane County. So I'm going to turn this over to Mr. Dingell to give us some opening information on that, and then I'll open it up to the board to ask questions. And if the board has questions as he goes along, catch my attention, because I don't want to skip over those. So, Mr. Dingell.
All right. Good morning, Chair Bozovich and members of the board. First thing I want to do is let you know that Ms. Betchart was planning on being here today. However, her deputy is sick, and so she needs to be over at elections doing her job. She is available she said she'll have her phone and we can text her if there's a specific question that isn't covered in the memorandum that I prepared. I should say I prepared that with a lot of assistance from Ms. Betchart. So the first thing I want to do is obviously reference, I gave you a very, what I believe is a very comprehensive memorandum, and it was the material that was published and online. I think it totals altogether 235 pages with the appendix. And then we also had some material that was submitted by other interested parties. So let's start with, and again, I know this is in the memorandum, but I'm going to try and summarize it, and I can answer any specific questions you have. So the first question is how does the citizen-led...
I want to clarify one thing, because this also, I think, is a question that came up. The material we got from other interested parties, how is that submitted and solicited, and were all parties solicited for information?
I don't remember the exact date, but I think when we finally confirmed the date of the work session, I sent an email to the people that I knew would be interested, which would be Ms. Neeland, who's the attorney for the petitioners in the aerial spray measure, and Mr. Gary, who is the attorney for Mr. Long in that same litigation, and advised them that if the work session was confirmed, that if they wanted to submit material, they had to submit it by whatever the deadline was, and I CC'd Ms. Jones' email on that. So it was those two, and I'm not sure how the other folks from Davis Wright Tremaine found out. I think they're just interested parties, so I presume someone told them.
Thank you.
All right. So the citizen-led initiative, as it's pretty clearly set out in my memorandum. That's in the Oregon Constitution, and I'm going to try and be very clear about distinguishing and using the right terms. Citizen-led initiative means there really is only citizen-led initiatives. Let's state it that way. And so what citizens do in the process is laid out there is that they, and it's parallel at both the state and local level in the sense that you just essentially swap out Secretary of State for county clerk if it's a local citizen-led initiative measure. And essentially what happens there is they put together their petition, there's a ballot title is written. In either case, it's presented to either the Secretary of State or the clerk, who reviews it for compliance with what's called the single subject rule. Now here's where the state and the local split, because at the state level with the citizen-led initiative petition, the Secretary of State also reviews it for compliance with the separate vote rule. Assuming it meets those two requirements, it's the Secretary of State authorizes at the state level the petition to circulate. They have a certain amount of time to gather a certain number of signatures. If they meet that deadline and the signatures are verified.
What is that length of time?
At the state level, I don't know off the top of my head. It's in the memorandum. It's by statute. And so, and the amount is set by statute. Actually, by Constitution, excuse me. And so then they circulate. If they're verified, it goes on the ballot, and the citizens vote on it. And there are some other things that it's reviewed for. Measures, initiative measures have to be legislative and not administrative. Some other things. The difference at the local level is that same process, and we have to insert here that there has been that process has been clarified as a result of litigation surrounding the aerial spray measure. What happens at the local level is same process, presented, reviewed for single subject, allowed to circulate, and based on what I'm going to refer to as the 2017 Judge Rasmussen opinion, once the signatures are verified, the clerk then reviews the measure for compliance with the separate vote requirement. If it passes that, then it gets placed on the ballot.
Can you say that again in order? First you said reviewed for single subject first and then circulated?
Then circulated, and based upon Judge Rasmussen's 2017 ruling in the Stan Long versus Betchart Dingle litigation, he ruled that the time for review for compliance with the separate vote requirement, which is found in ORS 203-725 sub 2, is after the signatures have been verified.
Mr. Chair, if I may ask for a clarification. Sure. So review for single subject comes prior to circulation. Review for separate vote comes after circulation.
Correct.
Thank you.
With the current state of.
And that's the law that's binding us. That's the law that binds us because it's a Lane County Circuit Court opinion.
And the separate vote is specific to charter amendments.
Correct.
So I want to make sure that's clear, not ordinances.
Correct.
Okay.
And so, yes, we're talking about charter amendments, and by our charter, those citizens have the right to do that. And again, since it's a charter amendment, that's like a constitutional amendment at the state level. It has to comply with that requirement. That's correct.
Now, Mr. Dingle, on the 2017 Circuit Court opinion, was that appealed to the
Yes.
Court of Appeals? And
Yes,
what then becomes the state, the impact of that on the whole state? You mentioned some of it's binding on us because it's a Lane County Circuit Court. Well, that opinion, right, was a Court of Appeals.
Correct. So and I'm happy to do it this way. That's fine. Well, it seems like things are rolling along here, so I'll do that. Yes. So after Judge Rasmussen made that ruling, he ruled that ORS 203-725 sub 2, that the legislature had the authority to control how counties amend their charter, and he interpreted that provision as requiring at the earliest time that it could be reviewed was after the petitions or signatures were verified and presented to the clerk. That decision has been appealed and is currently in the Court of Appeals. It has not been, it hasn't been briefed or argued. That opinion is only binding, legally binding on Lane County because it was a Lane County Circuit Court judge that made the decision, and there was no stay or anything of the judge's order. So unless and until the Court of Appeals or later the Supreme Court reverses it, that is the law in Lane County.
Yep.
All right.
Mr. Chair, one last. This is a question for a later response, but I'm going to be asking the question: why did it take so many years for this to come to fruition? The question being raised such as it is.
I can actually take that up right now. Bottom line is, based upon my conversations with the people at the Secretary of State's office and other county councils, it's just because charter amendments are, local charter amendments were up until very recently, very rare. The Secretary of State didn't even provide advice to clerks on how to interpret it because it came up so infrequently. I mean, if you look at Lane County, the last time there was a citizen-led initiative was in the early 1990s with the East Alton Baker Park charter.
Mid-90s.
Or mid-90s, when it was a long time ago.
My early days on the city council.
So as the chair pointed out, it's a little bit different process because between a charter amendment. Charter amendments are very unique because they carry these other requirements. The other way so that's a citizen-led initiative. Another way a charter amendment could get before the voters would be a referral from the board. And I know this question has come up, so I'll answer it directly. Does that somehow eliminate or obviate the need for a review for compliance with the separate vote requirement? The answer is no. It just, in my opinion, based upon what Judge Rasmussen said in 2017, the triggering event for the clerk to review a referral of a charter amendment would be when the board refers it, because there obviously is no signatures to be gathered in that instance. The second thing that is significant about Lane County is the opinion that was recently issued by Judge Rasmussen, because it clarified, at least in Lane County, how that separate vote requirement is carried out. And the petitioners were arguing that that the clerk doesn't really do a substantive review of the proposal, that more or less you just kind of look at it, and the judge made clear in his ruling last week that no, the clerk has to actually make a substantive review of the content of the measure.
Does that mean that Lane County was ruled by the judge to have violated that provision because it allowed the matter to go forward?
No.
Because it sounds like the judge wants the clerk to review it for more than just, is the petitioner a resident of the county and
No.
that sort of thing.
No.
So really, there's going to have to be, at least as things now stand, there's going to have to be the petition filed, reviewed by the clerk, signatures gathered, then reviewed again by the clerk and knocked out, as in the present case, or the clerk determines that it does comply and can go forward.
Correct. And
the citizens don't know at the point that they're circulating and asking 12,000 of their fellow citizens to sign this thing. They don't know if it's actually going to withstand that test.
That's
under these rulings, under this interpretation of the.
Of separate vote, not single subject.
right.
Yeah.
I would say that yes, they can. I mean, you can certainly do what, and we know from what happened at the state level that in Armada versus Kitzhopper, and that's the Crime Victims Bill of Rights. You may remember that. The rule is that the petition has to circulate in the form that it's going to appear on the ballot. So in Armada, the first time that was done, all of the rights, I can't remember, 12 or 13 or 14 of them were on one single petition. That got struck down as violating the separate vote requirement by the Supreme Court. The petitioners had to go back, create separate petitions for each individual right and circulate those, and then get the requisite number of signatures for each one of the rights to have those presented on the ballot. And that's what would happen here. You can't go backwards. So you'd have to, in an abundance of caution, it would be wise to break up these charter amendments into smaller pieces. But you're right. We didn't know, that was not ultimately finally determined, at least on the local level, until last week. But the key thing from Judge Rasmussen's ruling last week was that it was the kind of review that the clerk does. He made it clear in his ruling that the clerk is supposed to look at the substance of it, just like they did in Armada, and see does it change or require multiple changes to the thing. And he listed those in the opinion, which is an appendix.
Mr. Chair, Commissioner Sorensen has cast a shadow on my clarity, so if I may ask a question for clarity. The review for a single subject is statutory state, and the review for separate vote is county charter.
Okay, let me break that down. Yes, at the state level, it is clear for a state constitutional amendment, which is sort of the parallel to a charter amendment at the local level. The charter is our constitution, essentially. At the state level, it has been clear for some time because there's statutes that the Secretary of State reviews an initiative measure at the state level up front before circulating for both compliance with the single vote for single subject and separate vote requirement. However, at the local level for a charter amendment or an initiative measure, the statute did provide for the single subject review to occur before the petition was circulated. That was clear in statute. The part that was unclear was when the review occurred for separate vote compliance, because the 203725 has subsection 1, which says that county charter amendments shall be reviewed for compliance with the single subject. Okay. The good news there is that there's a state statute that says that that's supposed to happen before the petition circulated. So that's why the clerk has always done that. Subsection 2 contained the separate vote requirement. It did not, and there was not a statute that specified at what time that review was supposed to take place. That was the subject of the 2017 litigation. The parties disagreed. Petitioners argued that it had to be done in the first 60 days after the petition was presented or it was waived. Mr. Long contended that it should have been done before, at some point, I think he said a reasonable time. And the clerk and the county took the position that that because the statute was silent and the way it was written, that the time for review was when the signatures have been verified. And Judge Rasmussen, that's what he ultimately concluded that statute meant.
2017. That is under appeal.
In April of 2017, and that decision is currently being appealed.
Thank you.
Okay. But the significant thing last week was that we now have clarity, at least in Lane County, what the nature of the review is, that the clerk is actually going to dig into the measure a little bit, just like Judge Rasmussen did in his opinion, and determine if it violates that separate vote requirement.
Thank you. Thank you, Mr. Chair.
So that's the citizen-led initiative process and a discussion of the separate vote requirement. And that would apply only to, in our local world, a charter amendment. Okay.
So I want to clarify a couple things because the current initiatives that are out there right now that have been having these issues are all charter amendments. So before we move on to talking a little bit about ordinances, I want to make sure I'm clear. So statutory requirement we have to review for single subject, and that happens before circulation.
Correct. Clerk.
Yeah, clerk. Yeah, and the clerk does that for a charter amendment. There's also statute requiring separate vote, but it's unclear on timing of when that happens. But we now have a judge's decision that agreed with the county's stance that it happens after signature verification. Because the only thing that's clear about it is it has to happen before it's put to a vote.
Presented to the voters, correct. Presented
to the voters, I think, is the term they use. That's also statutory.
Yes, state statute, 203725.
And recently interpreted by a judge to happen at a certain time, and that's happened. So everything that's so far gone on relative to the processing of these initiatives to amend our charter have been controlled by state statute, and the process the clerk's undergone has been at the demand of state statute.
Correct.
So has there been any involvement by this Board of Commissioners in that process?
No. There is no place for the board. The board plays no role in a citizen-led initiative measure. If the citizens follow the procedure, meet the single subject requirement, collect the requisite number of verified signatures. It complies with the separate vote requirement. It goes on the ballot. There's nothing, the clerk doesn't have any choice. I mean, that's it. It goes on the ballot.
Concerning the use of the state statutes for citizens to amend the Lane County Charter, what is the rationale to invoke state law for the process by which that is done? In other words, I get it that the state constitution says that people live in cities, people live in counties, people live in the state, all have at their various government levels the right to petition their government to enact a valid ordinance or statute or charter amendment. And I get it that the state would want to have procedures for how the state voters would use to do that at the state level. What's the rationale to have the county voters be guided by state law on how to amend a Lane County charter? I really don't understand how we can say that the Oregon legislature gets to decide how people amend the Lane County charter.
It's because
Why are we under that law?
Because it's in the Oregon Constitution as part of the initiative thing. It says that the section of the Oregon Constitution that grants local citizens the right to do a local initiative measure says that the process by which, I'm paraphrasing here, but it says the legislature has the ability to regulate the way that it's amended, repealed, adopted. So that's where it comes from. So the 203-725 and those other statutes are the enactments by the legislature carrying out that constitutional provision.
And just to be clear, there's nothing on the Lane County website, Elections Division, that explains in any way the process by which citizens use their power to propose legislation. There's nothing that says, now you have to follow these steps, 1, 2, 3. There's nothing on our website.
I disagree with that. I think I defer to Ms. Betchart, but I believe that what she does is she has, because she certainly forwarded me things, I believe what she has is a series of links that take you to the various and sundry manuals that have been adopted by the Secretary of State. So if you come in and say that you want to run for office, you're a candidate or whatever, she'll point you to a link to the Secretary of State's website, and you go there and you click on it, and the Secretary of State has prepared a variety of manuals that are very sort of easy to understand. I mean, the one issue here, and back to what Commissioner Farr said, in addition to the passage of time, that statute 203-725 has a weird history. It is in my opinion, it was a one-off. In 1979, a group formed in Washington County, and they redid the entire county with a single measure. They changed the number of commissioners, made them elected, eliminated departments, and it generally caused chaos. And their representative went to the legislature, tried to get the statute passed in 1981. The Legislative Council opined at the time, along the lines of what you said, Commissioner, that they didn't think the legislature had the authority to regulate a home rule charter, so the measure went nowhere. That same legislator, same representative, came back in 1981, made the same pitch, and for whatever reason, I've dug and I can't find out why LC changed their opinion, but apparently they did, in the legislature adopted 203-725. There was already on the books a review that for the single subject, it's repetitive with the other statutes, so there was a time for it. Simply no one ever, in my opinion, because it was kind of rushed through, no one sat down and said, well, there isn't a statute that talks about reviewing for this separate vote requirement, because that was brand new in 1981. And quite frankly, I think because it didn't come up, it's never had to be addressed by the legislature, which is why we found ourselves in the position that we did when this issue was raised through the Stan Long versus Dingle Betchart litigation.
So
Go ahead, you guys more.
just want to clarify a little bit again. We are a subdivision of the state, so that's one of the reasons why we do have to follow state statute. Even though we have a home rule charter, we're only given home rule over, quote, matters of county concern that haven't been preempted by the state or have conditions by the state. So those statutes on our initiative process are actually part of that restriction on what we're allowed to do, home rule, so to speak. That's my understanding of why we follow state statute in our initiative process, and I think the Rasmussen decision kind of confirms that there is a statute out there that we have to follow. Until that decision is either overturned, that is, the law for Lane County. But I just wanted to kind of repeat one more time. Any time in this process has the Board of Commissioners taken a vote, made a decision, or had any influence over whether or not these initiatives get to the ballot or not?
No, again, clearly no. And I would point out that this is traditionally, this is a difficult spot for the clerk and the county because, again, it's a citizen-led measure. And the only reason that we ended up actually, myself and Ms. Betchart ended up in being named as defendants is because Mr. Long, a citizen, initiated the litigation, and it was clear that no matter what Ms. Betchart did, that we're going to get sued. It's the same situation that occurred with the most recent litigation. If Ms. Betchart and I had not concluded that it violated the separate vote requirement and went ahead to go given approval for it to go on the ballot, I'm confident, I've been told by Mr. Gary, that Mr. Long would have sued the county to stop that process. So either way, in both of these litigations, both of the litigation that has been that has happened as a result of these measures has been initiated by either the petitioners or by outside parties. There's just, the county hasn't, and that the board didn't make a decision there. That was a decision made by other parties. And that's set out in the second half of my memorandum where there's a very detailed chronology that talks, that sets out exactly the order and the sequence of those litigations and what happened.
Good. I just wanted to clarify that because I think there's been some spread out there that somehow or another the County Board of Commissioners was preventing these from getting on the ballot.
No,
and there hasn't been, this is citizens making law, the initiative process to amend our charter, which does not have a role for the county commissioners involved, which is one of the reasons why I wanted to go through this exercise this morning and agreed with Commissioner Farr to have this work session specifically on initiative process. So it's clear and understandable that when it's an initiative being done by the citizens, we don't really have a role. And basically the functions that the clerk and then with your assistants does are statutory requirements, and it's kind of a yes, no, you do it, if they could, get enough signatures, then we had a judge's decision that's told you to implement a certain statute. When they first turn in, there's statute that says it needs to be reviewed for single subject. It's not like you have a choice. There's nothing by the board that says, we don't take a vote that says you need to review this. We haven't directed you all are exercising statute.
those and statutes that were adopted by the Oregon legislature. That's correct.
Correct.
Not the board.
Not adopted by the Board of Commissioners.
No.
So just want to make it clear, there's been absolutely no role of the Board of Commissioners in the citizen-led initiative process to amend our charter for either the aerial spray ban or the community rights initiative, ever.
No, because back to what the question that Commissioner Sorensen asked, it's Article 6, Section 10 of the Oregon Constitution, which obviously the board had no role in adopting, And it says the Legislative Assembly shall provide by law a method whereby the legal voters of any county by majority vote of such voters voting thereon in any legally called election may adopt, amend, revise, or repeal a county charter. So that's where that authority comes from.
Yeah, and that's where the statutory
And that's-
authority comes from.
Yeah, that's where the statute that says review for single subject prior to circulation and the statute that was interpreted by Judge Rasmussen on the separate vote review. That's where it comes from.
Thank you. Any other questions before we move on to citizen referral of an initiative for an ordinance?
Just for those watching, Mr. Chair, starting on page 20, Mr. Bingle, the chronology that you talked about starts on page 20. The factual and procedural history starts on page 20 of the memorandum, which is available online right now. Thank you.
Actually, yeah, for both of them, the first litigation, which I refer to as the opinion in 2017 begins, the chronology begins at the bottom of page 16, and then I think the one you're referring to is the second litigation. It starts on that page, yes. Because it's important to remember that there are two. I know that sometimes people forget the one that was the 2018 opinion that was issued by Judge Rasmussen is a separate legal action from the one that he issued his opinion in 2017. They're unrelated. I mean, they're related, but they're separate litigations.
Yeah, they're related because they're both about that initiative, but it's two separate
Correct.
actions. So before we leave the initiative process, can you speak a little bit to the statutory requirements for review if a citizen went through an attempt to place an ordinance on the ballot to amend county code, not the county charter?
If it were not a charter amendment, then it wouldn't be the separate vote requirement. Single subject wouldn't come through. Wouldn't apply. Think about it this way: when you consider adopting an ordinance, we don't. Obviously, many ordinances cover more than one subject, right? And they contain multiple options in them, correct? I mean, that you set out different courses of action depending on what happens. So there is no review for single subject or separate vote. There is a review, of course. We always, as the legal officer for the county, we do review. And we would tell you, for example, if an ordinance were unconstitutional or if it violated another statute, because adopting that ordinance could expose the county to
Citizen initiative, though, would not go through any of that review process. You wouldn't tell the citizens it was unconstitutional.
No. If you are, that's the one unique thing about an initiative measure, which we should probably clarify right now, and explain the review of an initiative measure for these procedural requirements does not include a review of whether or not it's constitutional or legal. Specifically excluded. I think Judge Rasmussen made that clear in his opinion. So a citizen-led initiative can propose a completely illegal and unconstitutional measure that may very well get thrown out later, but it doesn't change the fact that it goes on the ballot and it can be voted on.
As long as it's not charter.
Well, charter only brings in single subject, separate vote, not constitutionality.
Yeah. So yes, a charter amendment could be proposed that met the single subject requirement, that complied with the separate vote requirement, but would be completely unconstitutional and thrown out later. That could happen.
Yep. So to be clear, if the citizens had chosen to do this as an ordinance, an amendment to our code for either of these initiatives, they would have come and presented the language to the clerk for approval to collect signatures. There would have been no review for single subject because that's not required. They would have been probably approved to collect signatures when they turned in, and if they had collected enough legal signatures and was verified by the clerk, at that point, separate vote would not be applied because it's not a charter amendment. And we would probably, at that point, qualify to be placed on the ballot.
Yes, and obviously the big difference between what you've described and a charter amendment is the board can change ordinances.
Yeah, and that's true. And I'm trying not to get into the confusion there.
Yeah.
But again, now we're talking about a citizen-led initiative to do a code amendment or basically an ordinance. Again, in that process, is there any role for the board? Can the board stop it? Can the board do anything?
Not if they go that route, no.
Okay. I just want to make that clear that, again, it's the initiative process is about citizens making law. And there really is not a role for the board statutorily or in code where we can impact or interrupt that process.
And again, presumably the reason that people do a charter amendment, and I think going back to that East Alton Baker Park one, is that the citizens wanted that to be essentially permanent and only changed with their vote. Because if you did an ordinance, the board could vote to repeal the ordinance day after the election. So, but if it's in charter, the voters, the only way to change the charter is with a vote of the people.
Right. Just like the Oregon Constitution. The
Yeah.
only way to change the constitutions with a vote of the people.
Correct.
So,
But just like the legislature can pass a law one session and repeal it the next session. A statute.
You mentioned that the board doesn't have a role in the initiative process, but in this case where the elections official made the determination that it violated the separate vote requirement after the signatures were brought in, after they were verified, then the elections official makes the decision that it violated the separate vote requirement.
Yes.
So it is true, as was pointed out, that the Board of Commissioners doesn't make the decision, but a county official does make the decision.
Right, because the statute requires it, and Judge Rasmussen indicated that in his 2017 opinion, that the clerk had a duty to review for compliance with the separate vote requirement after the requisite number of signatures
And so,
were verified.
and that issue is now on appeal.
That issue is on appeal in the Court of Appeals, correct?
Okay, thank you.
And I've, in a footnote in there, I've actually added I've given the Court of Appeals number, case number.
Commissioner Lykin?
Thank you, Mr. Chair. So there are 3 direct reports to the Board of Commissioners. Is the clerk one of them?
No.
Thank you. And another question I have related to this process itself. If a governmental body enacts an ordinance and then citizens say, you know, we don't like this, we're going to gather signatures, do they need to go through the same process that you're describing here?
It's the flip side of, it's the referendum process.
Because we went through 2 of those when I was mayor. They were both related to a single tax issue, but one was gas tax and one what we called a cable tax. And so the citizens didn't like it. And in fact, on the cable tax, we actually had one elected official who's serving on the Springfield City Council voted no to enact. This person was the only person, and then led the referral process to get it on the ballot, and it was overturned significantly. So I was just wondering if it was the same process. So.
Yeah, we just saw a recent example of this with the measure to repeal the hospital tax. The hospital tax. That was a citizen-led referendum measure to repeal it.
And significantly, the 2003 legislature passed a tax reform that was later referred and overturned. And that was the legislature that passed a sweeping tax reform in 2003.
So citizens have the right, both rights, to initiate and to repeal, initiative and referendum.
So, any further questions on the citizen initiative process before we move on to the portion of the work session on the referral process. Commissioner Sorensen.
I'm interested in knowing what other jurisdictions do in Oregon, such as cities or counties. What do they do to further help citizens understand their rights, to propose charter amendments or code amendments? What are they doing to actually be a little more welcoming to the idea that citizens have this right, and that the government, in my view, has an affirmative duty to actually tell people they have these rights and to help them to some extent understand what those rights are. In the same way that you have the right to register to vote, well, it'd be helpful if the government would tell you where you could register to vote or how you could register to vote. So I'm not suggesting that the government tell you how to vote. I'm suggesting that, as an analogy, we try to get the word out of how to be a proper voter. We don't want to advocate for or against citizen measures, but couldn't we be more welcoming? And aren't there other examples out there of jurisdictions that are willing to say, by the way, it doesn't threaten us, government, at all, that you have the right to propose initiatives. And by the way, this is a minefield of legalistic traps for the unwary. And even the Board of Commissioners has to set up a 2-hour work session to understand and try to understand. What I'm asking is, are there any better examples than, oh, by the way, you can contact the Federal Election Commission or the Oregon Secretary of State? No, they want to know how to do it in their own community.
Well, first of all, I'd strongly urge you to go look at the Secretary of State's website, because the manuals that they do are literally step by step, gives them dates. What you're asking is a very different question. You're asking, I think what you're saying is, does the clerk provide legal advice? And the answer is absolutely not.
Well, no, I made it very clear. I'm not saying that when we say, please register to vote, here's how you register to vote, here's where you put your ballot, here's when the ballot boxes will be open. We're not telling people how to vote.
No,
and the same analogy is, where do we actually say, by the way, we have a new rule in Lane County that was just announced, that you have to go through this process to get a citizen initiative on the ballot in Lane County because of the current state of the law.
And I think I've explained why there wasn't anything there prior to this. But I go back to, when I look at those manuals, they very clearly tell folks what to do. They didn't tell them about this because it didn't, but it was a matter of state law. And as I said, even the Attorney General in their advice to that they passed out regarding, or to the Secretary of State, which eventually went down to clerks, did not contain reference to this requirement of the statute. But that doesn't change the fact that it was on the books and that it has been law since 1981.
As far as I know, talking with some of the folks in the Clerks Association at AOC meetings, I don't think there's any jurisdiction that has some kind of active education program on the initiative process. But the information's readily available both through our elections website, and if you made a call, I'm sure they would be happy to talk to you over the counter and lead you through where the manuals are, and without giving legal advice, because the manuals are basically the step-by-step recipe. This recent thing with ORS 203725, though, probably isn't in any of the manuals because it's relatively new and under appeal.
I talked to Mr. Trout. That's exactly correct. He's the Director of Elections at the Secretary of State's office. And I do know from talking with Ms. Betchart on a variety of issues related to elections that she does, and I believe she's told me that she had regular communication with these folks about different things. She tells me she goes out of her way to tell people when they start different, for example, a minefield that you mentioned, Commissioner Sorensen. One of the issues that came up with these measures is that she every time that they got one of these, she pointed out to them that if you change petitioners, you need to stop circulating that page and come back. And that's another, she goes out of her way by what I'm saying is she goes out of her way to point out common pitfalls that and mistakes that people make.
And I would also point out the legislature has made signature collection extremely technical. And it's one of the reasons why there's a manual. You have to be very careful about how you collect signatures. You can't leave a petition sheet out on the counter of a business unattended, and there are various rules around the paper stock and everything else that has to be done with petitions, where it all has to be uniform, and you have to have a copy of the actual language with the signature sheet. All those rules are, and if you use paid gatherers, it gets even more complex. So but that's been driven by the state legislature, the rules on how to collect signatures, which I would agree is been made pretty complex. But some things have been made more simple in some ways. There's the ability to do online single signature printout sheets that you can download, print out, sign, and mail in, which is a relatively new addition to the initiative process. So it's having worked initiatives previously, before I was a commissioner, I understand it is complex, but it was made complex because of abuses of the system, I think, in the past, and the legislature's tried to prevent those abuses, and that's kind of why we have set, the manual for an initiative process, I think, is about this thick.
And again, I find the ones that are online at the Secretary of State's office, I think they're very easy to use in the sense of the way that they're put together. They're not. It's not like this where it's just a long line of text. It's got the short bullet point of what the requirement is. It's got a reference to the statute. I think if you do them online, you can even click to the link and it'll take you to the actual statute. So, and it does it in a manner that's like literally step by step. I think some of the things are numbered, like number 1, do this, number 2, do this, number 3, do this.
Yeah. So any further questions on the citizen initiative process? So why don't we move on to the board referral process, which is a different process because it does involve the board, and we do have a role.
So very clearly, just by definition, obviously the board would have a role here. So let's start with a referral, and I mentioned this briefly, and I'll restate it. So the first option would be that the board could refer a charter amendment. Obviously, that means, and again, I neglected to mention, that would mean that it would have to comply with the single subject and separate vote requirement. Obviously, there would be no review prior to a petition, so the time that the clerk would do the review for compliance with the single vote or single subject and separate vote requirement would be when the board voted to refer it. So it still would have to comply with that statute. It would just be the single subject thing would only happen after the vote.
Is that the same thing, single subject
No.
and separate vote?
No.
And does, back on initiatives, that would, the government is required, the elections official is required to review after signatures have been verified. It's required to review for both of those two things.
No, single subject happens before.
Single subject happens before.
At the beginning, before circulation.
Okay, and again, at the state level for a state constitutional
Now,
amendment.
what about for a county?
For a county, single subject is up front, separate vote is after the signatures have been
Can you
gathered.
distinguish that? What, it sounds a lot to me like the same thing, but
No.
it's not the same thing.
I'm going to try and distill down about 30 court opinions. I think actually when you look at, trying to think of which one does it best. I think Armada probably does the best job describing it. A measure or an initiative or a measure can comply with the single subject requirement and still violate the separate vote requirement. Again, think of it this way. The single subject is, it could be, well, let's take the look at the aerial spray measure. It dealt with a single subject, broadly speaking, so it met that requirement. But when it comes to the separate vote requirement, it violated it. And if you read Judge Rasmussen's opinion, I think he did a really good job. Essentially, that was the analysis that
Federal land, state land, private land?
yes, whether you could, the subject was generally aerial spray, bang aerial spray. That's fine. Okay, that's one broad area. But then you get into the separate vote requirement, and as he pointed out, you could be, the separate vote requirement is designed to give people an opportunity to vote on each issue. So again, back to the Crime Victims Bill of Rights. What Armada said was, look, a citizen might be in favor of allowing victims to speak at sentencing. That's one constitutional provision.
One part of the single subject.
That's a great, use that one as another analogy. It generally dealt with criminal laws. It met the single subject requirement. However, when you looked at the individual topics that were involved, some involved the Fifth Amendment or Article 1, Section 9 of the Oregon Constitution. Some involved, so basically you could be in favor of victims speaking at trial or speaking at sentencing, but not be in favor of less than unanimous verdicts for murder. So you have to be able to vote, the citizen has to be able to give effect to each one of the changes.
If we jumped over to the easiest of all of them, which would be a board enacted ordinance, if it has more than one subject and it has more than one item that would otherwise be subject to a separate vote requirement, if it were initiative, it could still be enacted by the Board of Commissioners. It could be both.
Right, but it's because those rules that I've described, single subject and separate vote, only apply to amendments to the Oregon Constitution and changes to charters.
Yep.
That's why you never hear legal counsel when you're considering an ordinance. You never hear us talking about those things because they don't apply. But then we do talk about other things like, for example, preemption or constitutionality or conflict with another statute. Does that make sense?
Yes.
Okay. So yes. So the referral process, clearly by definition, the board is involved. So if the board were to refer a charter amendment, as I mentioned, it would still need to meet the same requirements. It would just, the single subject would just be done at the time that it was reviewed and the separate vote requirement, or excuse me, referred. But again, there would be no constitutional review. So the board theoretically could refer an unconstitutional measure or a measure that was otherwise invalid. And then we go to the next thing would be to refer an ordinance. And again, that would be a different matter, because what I would be, again, sort of jumping ahead here, the difference with the referral process is now we do have to talk about, because there's no obligation of the board to refer a charter amendment or to refer an ordinance. And at that time, as your legal counsel, I would be talking about some of these things that we've talked about. I would be, for example, telling you, if you wanted to refer a measure that was clearly unconstitutional, I would say you're referring something that is unconstitutional that could that will most likely subject the county to litigation. And then, as I set out in my memorandum, beginning on page 11 through 16, I talk about the potential consequences for the county and the board members individually based on that action, because you don't have an obligation to do either one of those things. That's a discretionary act. And I will say, based upon, it's only cited in the cases are only cited in a footnote, the county actually can even get involved and in litigation if a citizen-led measure, initiative measure is passed. You saw that in Josephine County, where citizens passed a measure related to genetically modified organisms, GMOs, and even though they played no role in passing it and couldn't, they ended up being sued when people tried to enforce it, and that's currently what's going on in Lincoln County. Same sort of thing. A measure similar or identical to the one, the aerial spray ban, was passed, and now Lincoln County finds itself litigating because, again, you're going to be on both. There are people on both sides that are going to basically sue the county. One asking that it be enforced, another saying that it violates, that it's preempted by state law. And I talk about that. I talk about that as the potential liability here because if you were to consider that, I would be pointing out to you as a board member that, as I would with any other piece of legislation that the board was considering, I'd have to point out to you whether or not it's preempted by state law or whether or not it's unconstitutional. And in this case, I think I've set out in the memorandum that it's pretty clearly it is preempted by state law. And that's in fact a clause very similar to the one that's used with regard to herbicides and the Farm Act was included in the statewide GMO thing. It was intended to preempt local action. And that's exactly what happened. The measure passed. It was challenged in court. I attached that opinion as an appendix. A challenge was brought. The judge in Josephine County ruled that it was preempted by state law and threw it out. And the Court of Appeals affirmed. They did affirm without opinion. There's not a written opinion on that. It was just AWOP'd.
So I want to clarify a couple things. On board referral, of course, we're acting to our discretionary authority, so it's not something we have to do. But if we refer an amendment, a charter amendment, our referral does not get that amendment out of the process of single subject, separate vote review.
No.
So we would run, if we were to just simply try and refer as a charter amendment the aerial spray ban, we would run into the same issues that it ran into as a citizen-led initiative.
Correct.
So that's very clear. And of course, if the board were doing it, it would be a county employee, the clerk, that would be doing that review, even though the board was doing the referral. So we're subject to the whims of that same county employee, supposedly. And I wouldn't say whims, they're actually operating under statute. So it basically, even if the board does the referral of a charter amendment, we're under the exact same rules, basically, as the citizens when it comes to single subject, separate vote. And the folks that do the review would be the same people. Of course, we have the same options. We could also challenge those decisions in the court. We can't just simply redirect our clerk. We don't have that authority to tell our clerk how to do those reviews. I think we'd probably end up in court for misuse of power if we did. But that's
No, that's correct. And then the other, I think the statutes are set up in a particular way, and I think it's appropriate that, and remember, Ms. Betchart's somewhat unique in that she is, I think the majority of clerks in the state are elected, independently elected officials. But since I've been here, it's been very clear that the boards that I've dealt with place a high value on Ms. Betchart's independence, because that's essential to the process, that she's simply applying the law. She's not making, judgments. And so that's what she does. And the other thing about that process, Commissioners, you pointed out, is a referral of the board would not insulate that measure from being litigated. So even if the board voted to refer it, and even if the board thought that it complied with both of those provisions, that would not prevent someone from filing a legal action and challenging it in court. Exactly what happened here. So, I want to make clear that just getting it to that point doesn't mean that, again, the board, I think that's the point that you're trying to make, Chair, is that it doesn't insulate it from that review and doesn't insulate it from challenges from other people.
Correct. So just that's pretty clear. So if we move on to a board referral of an ordinance, similar to a citizen-led initiative to place an ordinance on the ballot, that then does not require single subject, separate vote review.
That's correct. And as I pointed out, it is also not, does not prevent the board from later repealing it or changing it. Now, the other difference is that, again, that is taking affirmative action. And so you're not required to do that. And so, like, as I said on the memorandum, you would see what the traditional role of county council, which you see whenever you're considering an ordinance, where me or one of my assistants would be providing legal advice to the board, saying, this proposed ordinance that you're considering, this clause raises constitutional issues, or this ordinance you're considering appears to be preempted by state law. You would potentially be passing an invalid ordinance, which would be subject to challenge later in a legal action, which would cost the county money. And as I've set out in here, I've obviously never encountered this because, fortunately, the board does listen to its lawyers. You do subject yourself to individual liability. A citizen could file an action under 294-100 if you said, obviously, there'd be a good claim that you were you were violating that statute if your own attorney told you up front, if you passed an ordinance that said we're going to go confiscate everybody who has a blue coat, I'd say you can't do that for a variety of constitutional reasons. And if you do that, you're going to get sued. And if you say, I don't care, go ahead and do it, and then we end up getting sued, you subject yourself to liability, personal liability. And as I indicated, usually, in most instances, the county is required to, and the state is required to represent and indemnify officials for claims brought against them as a result of their official duties, unless they engage in willful malfeasance, and certainly disregarding the clear advice of your legal counsel that one course of action is unconstitutional would certainly meet that standard.
Yeah. So that kind of gets to another subject here. We're talking about the referral process. It is discretionary authority being exercised by the board. So therefore, it does bring into question whether we're actually doing something legal and the ability to actually sue the county over the legality of that. When we get to, where we may have acted willfully and done something illegally, in the initial legal proceedings, until a judge actually rules that we've actually acted outside of our authority, there is kind of an obligation by the county, unless it's like extremely clear that we absolutely violate to represent us, and the suit's not going to be against Jay Bozovich necessarily. It's going to be Jay Bozovich and Lane County, and so therefore, there's going to be significant resource spent at least up through the first court decision.
Yes.
And the example of that is Dumdye v. Handy et al., where there was a lawsuit against the board for potentially acting, outside the legal bounds of the law, and there was accusations in that lawsuit that it was done willfully, and so therefore there was actually personal liability of some of the commissioners. But we defended that suit because one, it named Lane County in general, and two, there was no clear, you couldn't clearly say until the judge ruled that the individual commissioners had willfully violated the law, knowing and willfully violated the law, and didn't have. That suit cost Lane County, from my calculations, pretty close to $750,000. And a couple commissioners' personal money, so to settle. It was settled. It wasn't actually litigated fully out. So I'm not saying that agreeing to the settlement did not say have people agree that they willfully violated the law, but it was just a like a lot of settlements, it's one of the ways you stop the bleeding. But there is a perfect example of where the board was acting under its authority. A citizen outside said, hey, what you did wasn't legal, and sued, and the county spent money defending that suit, and ultimately that money comes out of the county coffers. There wasn't some special place that money comes from. It comes from we do have set aside for liability, but that liability reserve is filled from a indirect charge to all the different departments in the county. And when it's county administration that's involved in the suit, everybody pays. So whether it comes from Health and Human Services or the Sheriff's Department, to make up that $750,000 was distributed equally on all the county departments. So
if I can, I want to make clear one distinction here, okay? Yes, you are correct, but that the county and the state, for that matter too, with state employees, doesn't have any obligation to defend the 294-100 individual ethics issue.
Right.
Right. I'm talking about if someone made a
Ethics.
if a 294-100 claim came in, the person would be on their own. You're right. A lot of times it's going to be in conjunction with, it's going to be one claim in a complaint. There's probably also going to be a claim against the county, a complaint. And then it could, if you were to pass a clearly unconstitutional ordinance, I would expect, because you're the highest policymaking body, that there would be a 1983 action, which the county would, assuming there wasn't willful malfeasance, defend.
And for folks in the audience, 1983, U.S. Code 1983.
Yeah, I'm sorry, yeah.
Talking lawyers speak, I know what you mean. U.S. Code 1983, which relates to civil rights.
Correct.
And in the 19380 action, if somebody is successful, they also get attorney's fees, which
Correct.
is why the Dundee suit was so expensive, because it was done under 1983 also.
Right, that's correct.
So I just want to clarify that so people don't miss. So go ahead.
Yeah, I wanted to ask a question about the relationship between the referral powers of the Board of Commissioners for different types of referrals. We know there's a charter amendment referral. We talked about that a number of times at the board, because we've made charter amendment referrals probably 5 times, 6 times I've been here. Clarifying things like we're going to appoint a committee every 10 years to look at the future of Lane County, have a committee appointed. That's now in the charter, that kind of thing. And then we also make referrals for statutory, changes, code changes, and occasionally we make referrals for kind of a sense of the community. I don't know what to call it. Non-binding referrals, I guess, where the commissioners are, instead of holding a work session, they're asking the voters, what do they think about something? What is that third thing called?
The third thing is in the charter, it's called an advisory vote.
Advisory vote. And what are the legal standards for an advisory vote? So if the board goes, wow, this is an issue, it's multi-governmental, it involves the United Nations, it involves the federal government, it involves the state government, it involves the county, it involves the people of our county. It's very complex legally because of all these different legal relationships. We'd like to get that process going. What impediments are there to the board's use of that power?
There aren't. It doesn't carry any legal authority, so there's no single subject. There's no separate vote. You're not changing the charter amendment. There's none. I mean, in theory, you could put it to an advisory vote. Shall we confiscate everybody's property whose last name begins with a D?
And that's not going to be subject to a constitutional review, a federal statutory review, a state statutory review, any of the provisions of the Oregon Constitution dealing with initiatives or referenda.
No, because it's no more than a poll. It has no legal effect.
Yeah, okay. And is there a specific clause in the Lane County Charter that allows for this type of vote? I don't think the board's put one up since I've been on the board. It's not like we're using that power daily.
I'm trying to find the charter. It's one of the exhibits. I think it's it's a section 3 under elections.
Okay.
That's what I'm going off my memory.
So that's an opportunity in the event that the board concludes it doesn't want to put out any of these other types of board-initiated measures. And it's called what again?
In the charter, it's referred to as an advisory vote.
Advisory vote.
I think it's advisory vote or advisory election.
Okay.
And I think it's in the section under elections.
Okay.
I can't remember the exact article.
So returning to where I was going with my questioning on the ordinance portion and all that and legal ramifications. The advisory vote obviously does not have legal ramifications. It also has no effective law. That's why it doesn't have it, and why it has not been used. It also has a cost, though, of holding the actual election. But to refer an ordinance, because obviously the charter amendment, we still have to do single subject, single vote, separate vote, single subject, separate vote. To refer an ordinance that would potentially be, you would advise us that it probably is either preempted by state law or some other issue, unconstitutional, there's a legal issue with it. If we still went ahead and referred that, goes to the ballot, large, pro, con, committees are formed, people spend money on that, it passes, somebody takes it to court, it's declared illegal and struck by the courts, and they turn and come after the board. Is it potential that they could come after the board also for their cost of trying to battle it at the ballot box along with everything else?
I mean, they could, yes. Short answer is yes. They wouldn't, the 290, I think as I point out in my memorandum, the 294-100 provision applies to public monies that are spent. So that would include, in your example, the cost of the election. That would be one cost. And another cost would be the attorney fees that were expended, but I could imagine someone cobbling together a different kind of claim other than 294-100 for the expenses and include within that their claim damages, all the things that you mentioned.
Yeah. So in the Josephine County, where it was citizen initiative, so they haven't come back after the county for this cost, but there was well over $1 million spent by one side in that election. So, I imagine if we got into an election here, it's going to be millions of dollars spent on either side by folks. So we're looking not only attorneys' fees, we're talking about potential election costs, everything else. If we were to place these two initiatives, which there's been discussion about preemption and other issues relative to overriding state and federal law, and because we're a subdivision of the state, that's a difficult thing for us to do. If we were to place them on a ballot, and ultimately it looks like there's a possibility there'd be millions of dollars in liability, of illegal
I'd
liability.
say trillions.
Yeah,
I'd say trillions.
yeah.
It is interesting to note that in both of those situations where the citizen-led initiatives passed with no role by the county ended up being the defendant in the litigation. So in the Josephine County case, the GMO case, Josephine County was the defendant, and in
There was no real basis for a claim against Josephine County for the cost of fighting the election battle because
no.
they didn't actually place it on it.
No, but what I was pointing out is even though the county had no role in that, they ended up incurring legal expenses
Oh, yeah.
because they were named as a defendant.
Yeah, and Lincoln County's legal expenses are mounting today. But what I'm trying to get at is we're exercising discretionary authority in our referral process.
Right.
And with the exception of the placing a question, a non-binding question on the ballot, if it's either a charter amendment or an ordinance, we are exercising a discretionary authority that could open the county up to legal liabilities.
Correct, and individual liability.
Yeah, potential individual liability. I'm not, that's secondary to me because hopefully I wouldn't do anything that would expose myself to individual liability. But, for me, it's about what's the potential cost for the county because we all know we don't have a lot of resource out there. We're always balancing our budget on the head of a pin. I don't want to potentially expose us to millions of dollars, and thank you for interrupting me while I had the floor, and potential legal costs. And I just want to make sure I understand that with these two particular, one of the requests was for us to refer these two particular initiatives as ordinances, and we were even given copies of language for potential referral. And we now, it's pretty clear that the aerial spray ban has preemption from state law around who has authority to regulate that particular practice. The Community Rights Initiative, there's a lot of issues around preempting state law and us having precedence over state law that kind of gets around the whole portion of home rule that's described in the state constitution. So both of them seem to, on the face of them, have legal issues that probably if we were going to ask you, if we went through the referral process, you'd be advising us that we're referring something that has legal issues. So it's pretty clear we take action on that ordinance referral, and we're exposing the county to potential legal issues. But earlier, we were pretty clear if the citizens go through collecting signatures and refer these ordinances through a citizen initiative process, the only action we might get dragged into is like Josephine County, where they get named. They didn't do any real active defense. There wasn't a large cost to Josephine County in the GMO charter amendment lawsuit down there. That was it a charter ordinance? I don't know. But, it's still fairly low cost for them because it was the citizens that actually did that.
Right. Yeah. I mean, you're although I wouldn't minimize the cost. That I mean, I think we've expended what I would consider to be a significant amount of money defending these two, the two litigations just at the trial level. I mean, it's not.
Yeah, it hasn't been without cost to the county to start with.
Yeah.
So, but I wanted to clarify that if we do refer an ordinance and it has an issue legally, that we are exposing the county to potential litigation and legal costs as part of that decision.
Right. Depending on what it is that's referred, but as I point out on pages 11 and 12, and again, based upon what happened in Josephine County, which was again affirmed without opinion by the Court of Appeals, it's pretty clear that this measure as it's currently, this aerial spray one is preempted by state law.
Commissioner Lycan and Commissioner Sorensen.
Thank you, Mr. Chair. So, Steve, I'm going to read something to you that's in the information that you provided. I think it's fascinating. It's Professor Orville Etter from 1973. And what is interesting about this is what he stated in transmitting his draft in the 1973 statutory home rule legislation to AOC. Someone is bound to ask just what are matters of county concern. To this question, neither I nor anyone else can give a definitive answer. Matters of county concern is a broad, flexible concept that appears in the County Home Rule Amendment to the state constitution. The list of matters of county concern may be one list in 1970, a somewhat different list in 1980, and still a somewhat different list in 1990. We can get some idea of what the list includes at any given time by noting what particular state laws provide with reference to counties, what function counties are generally engaging in or being called on to engage in, and what are matters of municipal concern under municipal home rule. The part this is pretty wise going back 45 years. Especially when he says we can get some idea of what the list includes at any given time by noting what particular state laws provide with reference to counties. He made that statement in 1973. And I think, so as a subdivision of the state, I think, this is pretty interesting information because he states it's going to be a different list since 1970, 1980, 1990. Obviously, he passed away at a certain time. It was a different list in 2000. It's becoming a different list in the 2010s. But at what he's basically stating here is ultimately state law rules when you're a subdivision of the state. So if we're preempted, we're preempted. Now it's up to the state legislature to, if they want to overturn that preemption and refer it back to the counties, that's up to them. And really, I didn't read this, obviously, when I voted no on Tobacco 21. But when I voted no on Tobacco 21, my issue was I wasn't disagreeing with it. I just didn't think Lane County should be an island. It was a statewide concern. Now the legislature passed it. It's now in law, statewide. And even when I was mayor and they were talking about no smoking in bars and taverns, and people came to Springfield and said, you need to enact this because Eugene did. And I said, no, we're not going to, because the state is looking at doing the same thing. And the state eventually did. And so this is pretty interesting and pretty wise information that came from 1973, if you really think about it. And it just really jumped out at me. And I'm not asking for a response or anything, but I think but times are changing. There's no doubt about it. And if the state decides, you know what, these are more of county concerns, but maybe because this affects 10 counties more than the other 26, they can make that ruling. But until then, they have decided that counties are preempted. And I think as a subdivision, we have to honor that and work with them on that. And I just felt that was pretty interesting and how that jumped out. A statement made in 1973 and how that reflects in what we're doing today. So, nope, you can respond if you'd like, but I'm not asking for one.
I was just going to,
thank you,
just
Mr.
for the
Chair.
folks that are listening, Commissioner Lycan, you're referring to, I think it might be the first Exhibit A. It's something entitled the Home Rule.
It is.
Papers.
Yep.
And yeah, that was it's actually collectively referred to that way, but if you start reading it, you'll see that it's a series of, I think, 10 or 11 individual papers that was written by Mr. Etter, which was intended to be sort of a history of the home rule, the evolution of the home rule charter and the home rule process in Oregon. It's kind of looked at as the definitive word on that.
And he was steeped in public policy, and that was.
And if you look in the memo, and I've referred to it, that generally speaking, you're correct that when the legislature acts to preempt, they almost always, like they did with one of the statutes that I cited, they make a finding that, quote, a uniform statewide regulation is essential. and that local regulation doesn't achieve these benefits. So that's generally the language they use when they preempt something.
Commissioner Soren.
I thought our first session about the explanation of the initiative process was helpful to try to understand the whole thing. And I think that Commissioner Farr, in bringing up this idea of having a work session on the initiative was good. But I mainly brought up the idea of a work session on the referral process, because I thought that the citizens had gone to a huge amount of effort to gather 12,000 signatures, and that even though they were apparently being rebuffed at different levels by the Court of Appeals or by the Circuit Court or in their view by the county, that they did have a legitimate issue that the Board of Commissioners ought to consider. And one way for the Board of Commissioners to consider that would be to talk about doing a vote by the Board of Commissioners to the people of Lane County. Now, it seems like we would certainly have the power to say that this referenda could take the form of no aerial spraying of county roads. And I was thinking about that in the shower the other day. Wait a minute. Nobody's spraying Lane County roads with aerial spraying right now. But then I thought, well, wait a minute. The technology is evolving, and it may well be that we could see companies coming forward and saying, we have a new, cheaper way for you to deal with roadside spraying, and that is to send these drones down the roads and spray the problems that they identify. So it could be that the technology changes and that the Board of Commissioners, in responding to legitimate public concern about the spraying of the public and all of the stories of landowners being sprayed and citizens being sprayed and the health impacts of all that, the Board of Commissioners might say, well, wait a minute, we can't regulate what the federal government does on its land because we're preempted from that. We can't tell another community, Lincoln County, what to do. We can't tell the state what to do, but we certainly can regulate this practice on our own lands. We could say, we don't want to have aerial spraying on Lane County parks. We don't want to have aerial spraying on Lane County roads. We can modify what the citizens have come in with because of the apparent legal issues there. But we could modify this and say, we want to do something. We want to show that we are listening. We want to show that these are legitimate issues out there, and we want to do something within our power. We want to do something about it. Now, it seems to me that that having a work session like we're doing to discuss the modifications to those citizen proposals, because the citizen proposal is basically, here's our initiative, we rewrote the title, and we call it now something the county should do. Well, that's helpful, but that's just one part of the process, in my view, towards a goal of, well, what's within the power? Instead of us thinking, we are going to say, no, you didn't prepare your signatures properly, no. You didn't do this right, no. The timber industry comes in and says, they didn't do this, the judge agrees, now it's on hold until the Court of Appeals. That's all the initiative process. What I wanted to talk about, what I think is a more useful use of our time, that we have a opportunity to listen to citizen complaints about issues out there, but tailor it to the powers that we have. And I'm wondering if you have any suggestions of what those would be that would not violate the Oregon Constitution procedurally, that would be within the powers of the county, such as road spraying or such as spraying, aerial spraying of county lands, or any other health or safety powers that the county has to regulate health and safety. That's been a historic power that the county has.
Commissioner Sorensen, I think I'd have to, I mean, you'd have to look at whatever it is individually. I mean, you've made some points, but it's important to remember too that there are different things that it just depends on the level of preemption and what you're talking about. So for example, I'll give you a good example. This board could not pass an ordinance that allows 12 or 16-year-olds to drink beer in Lane County.
What about spraying herbicides on county roads using helicopters or drones?
If you're talking about regulating county
Yeah.
property, probably not an issue.
Okay.
But someone may challenge and say that that it is preempted by this statute, which says that you can't make local regulations. Mm-hmm. There's always going to be an argument when there's a preemption statute. We've seen some examples of that, quite frankly. Some of the cases that are cited in my memorandum are, or not in this memorandum, excuse me, another memorandum that I wrote. I did get into the issue of preemption, and there were some clear conflicts. And by that I mean, one that I remember specifically was the legislature preempted local building and something to do with local building activity. And the very argument that you're making was posited, and the court said that the legislature could do that. So
And I think we're seeing that play out at the national level, where the Trump administration is threatening California, and I think by extension, Oregon, and other states have enacted marijuana legislation that's directly in conflict with federal criminal law. And so you're right, it does come up time and time again in our system of federalism between the federal governments and the state. And I'm just suggesting that if there's interest on the board to respond to what I see as a legitimate public interest that's been expressed time and time again in front of the board, that instead of all these different pathways leading to no, I'd like to have a pathway that is leading to yes, doing what we can do.
So first, I'd like to let you off the hook. You weren't asked to do that research.
No.
So that's not what you came prepared to discuss today. So don't feel a need to answer that question, the legalities of what we have that ability to do without doing research. What we were asked to look at was specifically referral as an ordinance of those two initiatives. And that's what we were here to have the work session on today. And that's what I'd like to complete our discussion of, because we have to be out of the room basically by 11 o'clock for the city council. I will say that there has been significant discussion of the use of herbicides and pesticides on county properties. In fact, we completely banned it at one point, and then after citizens came to us, particularly the farm community, about the spread of invasive species along county right-of-ways, we re-looked at that whole process and had a citizens-led task force look at it that came to unanimous consent on a policy that would allow limited use for invasive species on county right-of-ways, and actually prescribed how the applications would happen. And I don't think we're in danger of suddenly having helicopter spray, because that wasn't what was described in the policy we approved as a board while you were here, Commissioner Sorensen. And in fact, there was folks from Beyond Toxics on that task force. So this is not like we have some widespread policies, that allow all sorts of things to happen on county property. We actually have a very clear and prescribed policy. And in fact, anything we use has to go through our Public Health Advisory Committee to approve the various, any chemical we might use. And then there's a whole set of standards around that. So I think we've been down that road, and we have regulated what we can regulate on county properties. So why don't we get back to what's under discussion today, which is whether or not we have, what are legal authorities, what are legal liabilities, and specific to these two, previous ballot measures as charter amendments becoming ordinances and the board taking their discretionary authority to refer them as ordinances, what that implications are. And we haven't even gotten to the discussion of who else could come and ask us to do this various shortcut to the ballot, which is basically what we're being asked to do, which is, we described earlier when we talked about the citizens initiative process, there is a process available to the citizens to collect signatures and have these ordinances go before the electorate on their own, where they don't get involved in the liabilities of the board taking discretionary action, where the county doesn't have as big a liability. And we might get caught up in some costs, but it's not a direct county liability. So, there could, I don't want to discuss this so much on this single issue as this is about the board exercising discretionary authority to refer things to the ballot at citizens' request. Think about this as, what if this was some other entity coming to us? What if this was Oregonians for Immigration Reform? And those guys wanted us to pass a ballot initiative that would basically say we're going to spend local money to enforce federal immigration law in direct violation of state law. And we put that on the ballot. Would that expose us to liability as the county and as individual board members?
Yeah, there's a statute that says you can't
Right.
do that.
Now, could Oregonians for Immigration Reform go out and collect signatures and place that on the ballot, if it was, as an ordinance?
Yes, absolutely. As I've said, and this isn't just me. The Oregon Supreme Court has said on numerous occasions that it is as clunky and as inefficient as the system is. The court says that is the system. That means that citizens have the right, if they want to propose a clearly illegal, unconstitutional measure, and they can go out and get the required number of signatures and follow the procedures and get it on the ballot, that happens. Even if and I think they've actually even used the phrase, even if, the moment that it passes into law, it's a nullity, a legal nullity. They have the right to do that. There's nothing, and they've pointed out on a number of occasions, there's nothing the government can do to stop that. The only way to stop that would be for, ironically, the citizens to gather to do an initiative to change the Oregon Constitution and take away the initiative, eliminate the initiative power.
But really,
or change it.
Yeah, I just want to make clear, though, there is liability involved in the county referring an ordinance.
Yes, because it's a discretionary act, and because of the two statutes that, if you're talking about in this with this particular measure, yes, because I've pointed out in my memorandum there are two statutes that very clearly preempt local action, and I didn't even really do a substantive constitutional analysis, but some of the other things in it certainly have issues in terms of if allowing people to do some of the things that it purports to do clearly present constitutional due process issues.
So, are there any other? Go ahead.
Yeah, I just wanted to say that in this discussion of how I would use or how the board should use its discretionary power, I would say if people want to come in and say, I want to have a ballot measure that says we should exclude all people from Lane County who are from another country, I would use my discretion and say, no, we're not going to put that on the ballot. So I think that the answer is we have to use our discretion in using the power to put measures on the ballot or not. What concerns me is I don't feel like I have made much progress with the idea that we would take an idea from the public, that the public's frustrated, that there's federal laws that allow this practice, there's state laws that allow this practice, there's officials that don't want to change this in various elective and appointed offices, and the public wants something done about what I believe is an injustice. And we have some powers. Now, true, they're hemmed in, and we're a government of laws, right? We used to say a government of laws, not of men. We're not a government of laws. We are a government of laws, and we should stay within the powers that we've been allocated. And that includes President Trump, who I hope will stay within his powers and not intrude on our powers. And I think that we do have powers to protect people in our county, using our health and safety powers, using our ownership that's in trust for the people of Lane County, whether it's parks, public lands, buildings, roads. And I think we do have certain powers, unique powers, because of our public health responsibilities that are identified in state law that we could use to do something about this unjust practice. But rather than move on that, I think we are getting this, procedural work session, which is great. We're learning a lot. I am. But I would just like to move to the next level. We've got a bunch of people specifically who have asked us to do something in a very elongated process. And today we're getting a briefing on what the process is, which is great. But I'd like to see us move to the next level. What are we going to do? Are we going to use those powers? Sounds like we have almost unlimited discretionary powers for an advisory vote under the Lane County Charter. That sounds like we have that. And it sounds like we have some powers within the opportunity to either change the law of Lane County as a board of commissioners, or if the politics isn't there and people don't want to pass that, maybe move to put it out for a vote. And I just want to know what we can do. And I agree with Commissioner Bozievich. Steve, you did a really huge research job on the legal issues connected to these two things. And I do want to thank you. And people that are interested in the initiative process and the referenda process, this is going to be something people will look at for years to come. It won't be quite as epic as Orville Etter and the University of Oregon Bureau of Government Research and Service in the 70s, where Mr. Etter was retained to do this epic study for AOC and LOC. But my point is, it's going to be something people look at for a long time to go, well, how do we sort this all out? And quite frankly, this work session is worth it just to obtain that. But I just want to know, maybe you would just say, well, that depends on the will of the board, which I think is a good answer. But what can we do to move forward on the specific issue that brought us to this, namely people concerned about not just herbicide spraying, and by the way, it's in our current policies on roadside spraying that we won't use certain herbicides and we'll use discretion, and there's been a huge reduction. We had a task force, people worked together, good news. But there was nothing in there about aerial spraying, nothing. And there's been nothing in there on aerial spraying of county parks. So those are, in my view, legitimate issues that are still out there, and the board may or may not want to move on this. I'm okay if we just have a straight vote. Thank you, citizens. We considered your idea. We're not doing it. At least that brings some finality to this. But if there's not finality, let's keep working on it. Let's keep working on whether we can do something.
Commissioner Farr.
Thank you. We had two different work sessions today so far. One of them, the first one, which I asked for, I'm satisfied with the results of that. I think we achieved some clarity surrounding that. The only question that I have remaining after the first work session is there a need for a county handbook that's easy to read, that is a guide for the initiative process? And you state, go to the Secretary of State's website. I've gone there. It's not particularly easy to read. So is there a need for that? That's a question.
Chair, or Commissioner Farr, I think that's a question that's best directed to Ms. Betchart. I will tell you this, that they do, I know, again, from dealing with her on a number of elections issues, one of the things that they really try and do is they work very closely with the Secretary of State so that everybody in all 36 counties is getting the same information in the same format. I can certainly, I know that from my conversations with Steve Trout, who made a presentation at our our fall conference. Really, essentially what they're doing is we are the sort of the tip of the legal spear here. They're waiting to see how this sort of plays out, if you will, and then they are going to develop their advice, and they get their, and this is where it gets, again, because of the different layers that are involved, the Secretary of State gets their advice from the Attorney General, who's going to tell them, you know, what they think the law is. That's the advice that they're going to pass out to the clerks. But I do know that Ms. Betchart places a very high value on what the Secretary of State says and how they're going to do it. So I can certainly follow up with her, but I know that they're really waiting for this to play out so that they can bring in some kind of finality, because again, this isn't like it's a Supreme Court opinion or a Court of Appeals opinion that's binding on the entire state. I mean, in theory, Douglas County could look at, you know, Judge Rasmussen's opinion and say, that's real nice. This isn't Lane County, this is Douglas County, and we're going to do X or we're going to do Y. So
Thanks for that. That covers it. When I was in the state legislature, I had a document that I used to hand out to, particularly to students who'd come to visit my offices, and it'd say how a bill becomes a law. And it wasn't a legal document, it wasn't legally binding, but it gave, you know, 8 different steps at how a bill becomes a law. And when we talk to Ms. Betchart about that, is there something that we can give to a high school student and say, read this and you'll know how to get something on the ballot? Simple as that. The second work session we had, I think we have a little bit less finality on. Commissioner Sorensen stated that we want to show that we are listening to citizen complaints and tailor it to do what we can legally do. I inserted legally. I'll also insert against what Commissioner Sorensen calls an unjust practice. So the pathway leading to yes on this, you know, I'm looking at history, different things that have been placed on the ballot by the Eugene City Council back in the late 90s, early 2000s regarding the West Eugene Parkway. 2 different votes that were yes, and then the City Council subsequently said no. So how do we put something on there that when it says yes, we can't say, this board cannot come back and say no? Well, the only way you can do that is with a charter amendment, which is very strict as far as the single subject rule, as well as the separate vote rule. So that's a difficult path to tread. So how do we put something on the ballot that is going to be legal, and when people say yes, they can trust that it's going to remain yes, and not overturned by a future Board of County Commissioners who may not agree with who may, like the 1976 Eugene City Council, disagree with what the voters said. Mm-hmm. So how do we do that? So the pathway to yes is something that I'm interested in exploring. I don't think we have an answer to that today.
Well, one thing I can tell you that if you want to talk about a definitive answer,
I said 1976. I meant 2006.
Yeah, I mean, you would have to if you want it to be permanent, as you've noted, it would have to be a charter amendment. It would have to comply with the single subject. It'd have to comply with the separate vote requirement. And here's when I heard you say, you know, like this finality, the answer to that question could take years. And here's why. Even if to know that it's truly final and that it's quote legal, if Ms. Betchart had agreed to put this measure on the ballot, there was already litigation filed against it. Presumably, if Mr. Long had lost that, if Judge Rasmussen had ruled the other way, he could petition the court for a stay, or the court could issue one on its own, which is what happened in Lane County. Circuit Court judge ruled in favor of some petitioners, and the Court of Appeals, which would have left their petition circulating and doing whatever they were doing, Court of Appeals issued an order stopping it. That case is going to take years to litigate. So the voters could pass a measure that collected the requisite number of signatures. If someone had made a challenge to it, it might be 2 or 3 years later, the Court of Appeals could come down and say this measure never should have been on the ballot. It violates the separate vote requirement.
And that underlines what I'm stating is that we don't have any finality. There's no reason, there's nothing that we can vote on here today because there's a great deal of research that needs to be done surrounding it. Another example I'm going to give is ballot measure 5 and ballot measure 47, both initiative processes. Ballot measure 5 was pretty broad sweeping in terms of its rewriting of state tax laws. It was flawed. Everybody who looks at it says, yes, it was flawed. So they changed it before ballot measure 47 came out. Ballot measure 47 came out and it was illegal. It had to be fixed by ballot measure 50, which was referred by the state legislature. So anybody think this is complicated? Yes, it is. It's absolutely complicated as to how do we get to, what is a pathway leading to yes, quote unquote. And I have that question. I'm going to walk out of this room today with that question. What is a pathway leading to yes? Because it's caused a great deal of consternation when you think you have a path leading to yes, and it turns out that it was just a long, expensive, arduous, drawn-out pathway to no again.
Commissioner Soren.
So I just want to get to what's the next step. We have at least, 3 choices, I guess, in my mind. One is to work on the idea of a referendum, a legally competent referendum. The other is to work on a advisory vote, and the other is to do nothing. So I would like to propose that we continue this discussion, but now outside of the context of an initiative and in the context of an either advisory vote under the Lane County Charter or a measure that would be a referendum to the voters, and not on just any subject, but on the subjects that have been raised in the public comment and by the proposals that the citizens made, and maybe even get to the point of having a staff presentation on what's available, what are those options, and secondly, a public hearing on the topic so that people can voice their views on what they think would be helpful, specific to the matter of aerial spraying and the difficulty of crafting legislation that would comply with federal and state law. So that's kind of my goal. But I also don't want to prolong this. And if the board just says, well, we're done, we don't want to hear more on this, and we just pretty much would rather say, all things considered, there's really no pathway to yes. And so why waste people's time? Why not just, call an end to this and let the public take whatever actions whatever rights they have, and we will just keep doing what we normally do. So that's the way I would pose the next steps.
Did you propose a public hearing? Did I hear that as part of your?
Yeah, clearly. But I want to see the staff work done on what is legally possible in the aerial herbicide arena, and then have a public hearing on different models of what we could do. And that way we keep this moving toward a possible yes, or like I said, I'm a pragmatist. If there is an interest in this besides me on this board for it, I get it, okay? And I don't want to prolong this and have us jump through a bunch of hoops and spend a lot of money that we may not really want to spend. I'm okay with the answer, no, public. I'm okay with it. I don't like it, but to me, it's a better thing than just dragging it out if there's really no interest. And I get it, because I've worked on this issue for 40 years in politics, in Congress, in the Oregon legislature. So believe me, I know there are people that are dug in against doing anything to address the issues that I believe are significant. So I respect the idea that we would just call an end to it, but I also would like to get a decision.
So we spent over 2 years in a process to develop our vegetation management protocols. And I believe, that, and in that process, we had a task group that included beyond toxics, it included people for alternatives to pesticides. It included folks from our Public Health Advisory Committee that have medical degrees. And they came to a unanimous consensus for a policy that I think is a very reasonable policy dealing with what we have jurisdiction over, which is county lands, when it comes to pesticide application or herbicide application. And we have just recently, and we're coming close to adopting a strategic plan for Lane County for the next 3 years. And that strategic plan has got many efforts in it around public health and other issues that the rest of the county finds that we need to address. And we went through a public comment process to develop that strategic plan. Now, Commissioner Sorensen is asking us to expend significant resources relooking at an issue we've spent significant resources looking at and is not contained within our strategic plan that we're getting ready to adopt. So I'm want to just talk about whether or not we want to do a referral as far as moving ahead with some process to look at something we already spent 2 years doing, and whatever else he wants to do is actually outside of our authority. I don't really think we need to be spending time and money doing that. We've heard from legal counsel that there is a process the citizens can go through if they want to have something placed on the ballot. We've also heard that if we actually refer something that is not legal, we are potentially setting the county up for a large financial liability. So, you know, for me, I'm willing to end the discussion on at least the referral of these two ordinances. I don't think exercising our discretionary authority to give one group a shortcut to the ballot while exposing Lane County to large financial liability and legal cost is prudent for this board to do. And I also think it's prudent to let these people know now that decision so they can exercise their right of citizen initiative if they wish to place it on the ballot. I think that's also prudent. So for me, I'm willing to potentially end the discussion of the referral process today, and I'm not really open to opening the whole issue of county jurisdiction on herbicides and pesticides because we've spent a significant amount of time on that. And it's not part of our strategic plan, and part of our strategic plan is to keep us from chasing squirrels. And we need to focus on what the county thinks are our most important goals and directions with our limited resources. So I'll entertain thoughts from other commissioners at this point. We need to wrap up because we're almost to 11. I think we've heard from you. I want to hear from the other commissioners.
Yeah.
I mean, is there any interest in moving further with the referral process at this time? The referral of an ordinance.
Well, I once again, my satisfaction with the second work session, I don't think we completed the work session, quite frankly. I don't think that we have answered the question, what is the way to yes? Now, your response to that, Mr. Dingell, was that it's a lengthy process to determine what we could legally do.
Well, if I understand the question to be what is the, what yes is, if it's how does this measure as a charter amendment get to the ballot, we actually now, we know subject to what happened with the Court of Appeals that the petition is presented. If it's presented in the same form, it will comply with the single subject rule. But obviously it needs to be, they need to get with their legal counsel and put it in a form that will pass muster under the separate vote requirement and circulate the petitions in that manner and get the requisite number of signatures.
Okay.
And I mean, if you're asking what is the path to yes, that's what it is. If yes is getting this on the ballot as a charter amendment, that's the path to yes.
Mm-hmm. And the option for the folks who may be paying attention today, here or elsewhere, would be to circulate an initiative initiative to get something on the ballot regarding an ordinance as opposed to a charter amendment, if they wanted the same kind of language that was contained in the initiative that's already been
Right.
de facto rejected.
Yeah, they could, yeah, and again, I was just thinking, I was speaking in terms of a charter amendment because that's the way this is posed. Yes, you're correct. That would be an alternative, with the understanding that it would be simply a piece of county legislation and thus subject to change or amendment without a vote of the people.
And that the latter could be the referral of the board or the referral of through the initiative process.
Correct.
All right. Okay. 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 I guess at this point, the initiative process seems to be a legitimate move forward. Okay. All right. So I have nothing to. I have no votes that no motion that I'm going to make at this point in time, unless it were to continue the discussion regarding the board's. Commissioner Sorensen talked about using our discretion to determine what we spend our energy, resources, and time on. And I agree with that. We have to use our discretion as to what we spend our energy, resources, and time on. And we do have we have our strategic plan in front of us, part of which is a safe and healthy county. One of our 3 goals is a safe and healthy county. So that means to me that moving forward with anything that is in response to a safe and healthy county is definitely in our strategic plan. I don't have a recommendation as to the county moving forward with a referral to the ballot at this point in time. I think that the petitioners have an option that they can generate the same energy that they've already demonstrated that they can on a process that was ultimately rejected by a court decision. So.
Well, unfortunately, we're going to be limited by time because city staff is on their way to set the room up for them. It sounds like there is no direction that's coming from 3 board members for staff to do anything further at this point. I will, as a member of the Agenda Committee, have this come back up because it sounds like we did not finish our business today. So at this point, I'm going to adjourn the board meeting and we'll call it at that.